You are listening to the Justice in Heels podcast with me, your host, Danielle Hayward. Join me as I discuss interesting legal topics with inspiring female legal professionals who paved the way for the rest of us.
Hello and welcome to the Justice in Heels podcast. Today we are speaking about the rights of domestic workers and I'm joined by Kim Harris. Hi Kim, welcome to the podcast.
Thank you, Danielle. Thank you for having me.
So before we start, can you maybe just tell our listeners a bit more about yourself?
So I've predominantly been in the labor law sphere for probably about almost 30 years now. And yes, it is one of those things that it has to, I believe, be a passion because it's such an ever-changing environment that you have to stay on top of things, not just in terms of domestic, but I think in terms of all employees and changes to labor legislation and things like that. So I'm from a company called CHA Group. I'm actually own a division of it called CHA Consulting. We've had the business for a considerable period of time. We only focus on the assisting employers, given the fact that it's very, very difficult. We don't like to wear two hats when having to go before the CCMA and things like that. So predominantly we only assist employers. So anything from your domestic worker employer, anything up to your small, medium businesses, specializing in obviously the labor law side, payroll outsourcing, and so everything that goes hand in hand with running your business at the end of the day. So yeah, so that's just a bit of the background in terms of where I'm from.
Fantastic. And can you maybe tell us why you are passionate about labor law or why you decided to go into labor law?
Yeah, I think because it's such a diverse, it's one of those pieces of legislation. It's neither black or white. There's just so many gray areas. When you look at just some of the wording, I wouldn't call it manipulate, but you can use the act to your benefit if you know what your rights are. And a lot of employers always feel aggrieved, if I want for a better word, that they feel that it's unfair that they have to go to the CCMA. They feel it's a one-sided process. But at the end of the day, if you're using the legislation for what it's intended, and which is obviously fairness at the end of the day, you should not be concerned when you appear before the CCMA for, let's say, having dismissed somebody because you know that you have followed the correct procedures and that it was for a fair reason. Those are all the important things, obviously, that a commissioner will take into place. To take into account. So I think because it is just such an ever-changing arena, especially now. We've now got COIDA, we've got national minimum wage. Those are all things that were never there before in terms of having that protection for domestic employees.
Fascinating. So we know that some legislation only applies to workers, everybody that is seen as a worker. So can you maybe just tell us, are domestic workers seen as workers or employees in the eyes of the law?
Most definitely, yes. So any employee, whether it be a domestic worker or any other person that renders or assists an employer with the carrying out of their business, as soon as they're working more than 24 hours in a month, they will be classified as an employee for all intent purposes of the basic conditions. And then there's certain requirements in terms of the LRA, which will apply a test in terms of whether an employee is an employee or not. So yes, I know a lot of the older times of talking about it was saying that I've got a CHAR, meaning she might only work 1 or 2 days for me. A lot of times that they say, yes, she's only a temporary worker, but she's been working for me for the last 20 years, 2 days a week, sort of thing. Then she's no longer a temporary employee, and she's got certain rights that are afforded to her under the basic conditions. So it's not the full extent of what a 5-day or a 6-day week worker would be having, but as soon as anybody's working for more than 24 hours in a month, then they are considered to be an employee.
Okay. So which laws regulate domestic worker rights in South Africa?
Well, now all of them. And COIDA, which is workman's compensation, never used to have a benefit there for domestic employees. There was a case a few years ago where a domestic worker, her family actually took the matter on to, I think it was the Constitutional Court, and they found that it was unfair because I think it was their mom that had been injured at work. There was no cover or no protection afforded to her at the end of the day for the disability that she sustained. It took quite a period of time before this legislation was actually eventually then, let's call it, legislated and enforced on employers, domestic employers. But it's quite interesting to note that very few domestic employers have actually gone and registered themselves with COIDA for their domestic workers, and it's quite worrisome because the employer needs to realize the situation of an injury on duty and what the ramifications are should they not be registered. In terms of them not reporting an incident or an accident. I mean, there's actual that they could face actual criminal prosecution as a result of it. So in terms of the laws that would apply to a domestic worker, it's your Workmen's Compensation, your UIF, your Labour Relations Act, your Basic Conditions of Employment Act, and then your National Minimum Wage Act as well. I think I've covered pretty much, that's all of them. Yes, yeah.
Yeah. Okay, so I mean, you now mentioned UIF amongst other things. When and how should an employer register their domestic worker for UIF?
Okay, so as soon as a domestic worker is, like I said, works more than 24 hours in a month, so the employer would have to register as a domestic employer with UIF. They can either do it online on the portal, or they can do it the old-fashioned way and fill in the declaration form, registering themselves as a domestic employer. Once they've got UIF reference number, they will register the domestic worker for UIF. Obviously, that's the 1% from either party that then gets contributed. Some employers do it monthly, some do it quarterly, some do it just pay it up annually, because a lot of times it is such a small amount, and just pay it up in advance. So that is very, very important. What domestic work employers need to realize is that the Department of Labor has got, although they may not just enter your house without your permission, they do random inspections within suburbs, and a lot of times within the residential estates, where they come and they will leave a notice to say, listen, I've been here, would like you to provide me with the following. And the failure to do so, once again, has ramifications in terms of compliance orders and things like that for not doing it. And they're generally they're going to ask to see contracts of employment, proof of pay slips, attendance registers, UIF. They're going to ask for workman's compensation, proof of registration, proof of payment. So those inspectors, you cannot just say, well, turn a blind eye and say, I'm not complying, I'm not going to provide. It's just going to create a big problem for those employers. Just on that, in terms of foreign nationals, which is obviously a whole different topic, employers need to be very, very cautious when employing a foreign national to ensure that they've got a valid work permit or asylum seeker documentation that is still valid, have it verified through Home Affairs to make sure that it's not a fraudulent document, because those workers are also entitled to be registered with UIF and have contributions, and whether they are legally or illegally within the country, even they are protected from an unfair dismissal as well. So nothing stops them. Employers think, oh, well, they're illegal, they can't go to CCMA. But that's another old wives' tale, unfortunately. They're afforded the same protection in terms of what the Act says. The Act doesn't refer to only documented or legal workers. It refers to an employee. It does not dissect that any further.
Okay, so on the topic of UIF, I mean, like, this is something that I read a lot on social media. A lot of people want to know, can they actually register their domestic worker at a later date and then just like back pay the UIF, or is that not something that you can do?
You can, if some employers, they say ignorance is not an excuse before the law. But sometimes employers are not aware of these things that they should have done. So nothing stops them from obviously registering, but you cannot now go to the domestic employee and say, well, you've been in my employer now for 5 years. I'm going to have to now take the last 1% for the last 5 years, and I'm going to deduct that from you and make you pay it. Unfortunately, that boat has sailed already. The employer should have been deducting that and maintaining those payments right from the start. So the employer is going to have to be the one that's going to have to then obviously pay those full 2% contributions for the period that there's been no contributions. So it's not advisable. One cannot stress enough, especially in an employment relationship, how important paperwork and compliance is. It's not a nice to have anymore. It's a must have. It is just unfortunately one of those things. You can try and rectify it, but you don't want that unnecessary attention drawn to you, because that inspector is going to keep coming back to you every year to come and make sure that you are still complying and have still continued with those payments and everything is still up to date. So it's not worth it.
Yeah. Okay. And then let's say you are a domestic worker and now you realize, listen, I am working more than 24 hours a month. I'm maybe coming in like twice a week. And my employer definitely did not register me for UIF. They're not not taking like the 1% that they should. What can they do? Is it simply as easy as just having a conversation with the employer, maybe just to bring it under their attention? What would you recommend they do?
I suppose it is a bit of a tender topic, because depending on the relationship that the parties have got, the employer might not like this idea of an employee coming and saying, well, I know what my rights are, and I want you to afford those rights to me. You see a lot of times on social media where there'll be somebody posting saying, yes, but my mom's been working for the people for 20 years. Now she's been requesting this, this, and this. And now they're saying to her, well, now take your bag and go. So if it's not an open conversation that the employee feels that they can have with the employer, unfortunately, their next option or their next step would be to actually then go and report it to the Department of Labor. And they will then obviously then send out, they'll make contact with the employer to establish and ask for proof, and try and resolve it that way. Alternatively, if it's not going to be resolved, the employer is going to find themselves faced with them issuing with a written undertaking from the Department of Labor. If they fail to comply with that, then they're going to sit with a compliance order that then is going to have them sitting in the labor court. And if you look at how strongly the labor court has been dealing with employers that sort of want to brush off or think that the labor court doesn't have the power or doesn't have the teeth to actually take them to task. There's been a few instances now where employers that have not complied with arbitration awards and things like that, they've been held in contempt of court, and they've been given hefty fines as a result of that. I mean, and the failure to pay that fine has then again got an actual prison sentence that can be linked to it again, as of for being in contempt of court. So thinking that the CCMA and the labor court is just merely just a scare maker, and it has no powers, the employer would actually be not doing themselves much justice in actually thinking that is the case. They do have the same powers as all the other courts. The CCMA obviously can only render arbitration awards, but if those are not enforced, they've got the power to make it an order of court, and then the employee's got the right to go and enforce that.
That's very good advice. Thank you for that. So on that note, are there any significant gaps or weaknesses in the current legal protection of these domestic workers?
I am seeing, once again, going back to social media and looking, people will ask, oh, what am I supposed to be paying my domestic worker? She's working, I'm looking for, or they'll advertise a position saying, I'm looking for somebody to work 6 days a week, sleeping position, working from 7 to 7, looking after children, cooking, cleaning, and then they want to offer them, let's say, 2,500 or 3,000 rand a month, and then everybody jumps on the bandwagon, and someone's saying, oh, I'll work for that money, and so forth and so forth. But at the end of the day, the National Minimum Wage Act regulates what the basic minimum is within that sector. And currently we're looking at, what was it here, 25 Rand 42 per hour is what the minimum wage is. For the first period that the National Minimum Wage Act came into place, the domestic workers were below that, and they worked over a period of time to actually get them increased, that they're in line with everybody. So for domestic workers and your farm workers, which farm workers also fall under this sort of same sector, that would be the minimum wage that they're entitled to. I think that is, a lot of times the domestic workers are desperate. It is, they are single moms, sole breadwinners with kids, desperate for work, and they're willing to work for below what that national minimum, what the wage is. But it's not going to help either party, because somewhere down the line the relationship's going to go sour. That employee is going to go to the CCMA, and the CCMA has got the power in terms of the basic conditions to actually determine a matter where the employer has not been complying with the act, and they can backdate any underpayments. So again, you might be sitting with somebody that's been with you for the last 3 years that you've been underpaying 1,000 or 2,000 Rand a month, and 2 years down the line you're going to sit at the CCMA and you're going to face an award that you're going to have to pay up within, and it's not something you're going to pay off. The commission is going to come and say, well, this is payable within 14 days or 10 days or 30 days or whatever the case might be. So the CCMA has got the power to deal with us. So we're not now waiting for the Department of Labor to come and go through the whole process. It's a lot more swifter going through the CCMA. And employers need to be aware of that. And that's also very important, is any notices that you get to appear at the CCMA is not to ignore it. You definitely need to attend to it. Ignoring it's not going to make it go away. It's just going to make the situation worse. And then to get those awards set aside, if you've been aware all along that there is this dispute, you're not going to be successful in having that award taken on rescission or even taken on review. They're just not going to grant it.
Okay. So what policy changes or reforms do you believe are necessary to better protect these domestic workers?
I think currently they've obviously got the sectoral determination, which covers them, which is the sectoral determination 9 of the basic conditions. So it's almost an annexure to the basic conditions. You've got different sectoral determinations. You've got one specifically for domestic workers. They've now got obviously protection in terms of workers' compensation, the national minimum wage. So the only piece of legislation that is not applied to them is just the Employment Equity Act. And so in terms of the rest, they've got the same rights that is afforded to every other employee-employer relationship that is out there, whether it be corporate or blue collar, or whether it be a domestic worker or a gardener.
Okay, so Kim, I mean, like, you've shared a lot of very interesting information now, but is there anything else that you think employers need to know if they have domestic workers?
Well, I think just the basics are important. Just an interesting fact, the CCMA statistics 2022, 2023, there were 184,000 disputes that were referred to the CCMA. The domestic sector makes up 5% of that, which is about 9,200 referrals. So employees, whether you might think she's illiterate or does not know her rights, are very, very aware of their rights. They've got young children, they've got teenagers that are very, very with it nowadays, that understand what goes on within the world, within the marketplace, access to Google. I mean, Google is an amazing tool. You put in a few words and they're going to realize soon enough and be able to educate mom or dad that doesn't know what their rights are. So the fundamental basics are exactly that as outlined in the basic conditions: a contract of employment, an attendance register, pay slips, And then we then come obviously then to COID and UIF. Those are the most important things. And then, yes, treating each other with mutual respect. It's not just a thing of, well, I just don't like my domestic worker anymore. I want to retrench her. Whatever rights are afforded to every other employee within the country in terms of rights and processes are exactly the same rights and processes that are afforded to a domestic employee. So, as I said earlier, ignorance is no longer an excuse before the law. The commissioners are not going to accept it. The Labour Court's not going to accept it. So employers need to really, really educate themselves, and if they're not sure, obviously get the right guidance and get the right advice at the end of the day.
Kim, thank you so much for joining me on the podcast today. I
It's a
think
pleasure.
you've shed some light on a very, very important topic. So, I mean, where can our listeners reach you?
We've got a website. It's www.chagroup.co.za. And my email address is kim@chagroup.co.za. They're welcome to drop me a mail, reach out via our website. We do have an online form that can be filled in. And yes, we're currently busy with an online store that we're busy uploading at the moment. So soon employees will be able to purchase at a relatively low cost contracts of employment and things like that they would be able to then tailor make for their working space with their domestic workers and so forth.
Thank you for listening to this episode of the Justice in Heels podcast. If you enjoyed this episode, feel free to share it with your friends on social media and tag us. As this podcast has a legal element, just a quick disclaimer that all views expressed in this podcast are not necessarily the views of the firms, companies, or brands that we are associated with. Until next time, goodbye.